What's up, everybody? Welcome back in. We've got a tough one today that I think is a really interesting learning experience. It's one of the most commonly asked questions when we watch police interviews, arrests, body cam footage, interrogations, whatever it may be. It's a discussion about Miranda rights and what happens when they're violated. How much of a stickler do the officers have to be? What evidence does a defendant need to get confessions or certain statements thrown out? And we have all of that and more in today's video, where we discuss Chad Doerman, who, if you remember back, we watched some of the body cam footage of his arrest, what happened when police showed up to his house after he took the lives of his three young children. And we know that he has already confessed to this crime, that there's a lot of evidence against him, but some of that evidence has gone away. As a spoiler alert, the court has suppressed some of Chad Doerman's statements and some of his confessions. So we're going to go through today and look at what allegations the defense attorneys made, what the judge agreed with, what the judge didn't agree with, what's thrown out, what's staying in, and we'll discuss if he can or will still plead guilty to this, and if the state still has enough evidence to convict him, from my perspective and what I think from what we've reviewed in this case so far. So if you guys are interested in this content, let me know by hitting the like button on the video and commenting in the comment section any questions or thoughts that you have as we go through this process. It's kind of a good overview of Miranda. And if you really want to read 5 or 10 deep dives into cases that really create this case law and how it works, I encourage you to read the entire 31-page order. We are not going to read all 31 pages together today, but we are going to look into a lot of it, and we're going to dissect a lot of it together now. All right. This is the decision and entry on the defendant's motion. First thing we're going to review is the pertinent factual background. The defendant is alleged to have killed his three young sons, 7, 4, and 3, on June 15, 2023. All were shot at their family home. And then they give the location. He also seriously wounded another child and his wife. The defendant was apprehended at the scene and immediately taken into custody. He was secured in the backseat of a deputy sheriff's SUV cruiser that was parked alongside the road where he lived, some distance from the actual scene. He remained in this cruiser for about 50 minutes until he was transported from the scene to the sheriff's office. A Claremont County grand jury returned a 21-count indictment against the defendant on June 22nd, 2023. He stands indicted on 9 counts of aggravated murder, each coupled with 3 capital aggravating circumstances, 8 counts of kidnapping, and 4 counts of felonious assault. We broke that down, I think, with my dad. If you guys want to check that out on the Doerman playlist on our YouTube page for more of a deep dive into that factual background. But what gives rise to this motion to suppress these statements? Let's take a look. And like I said, we're going to be hopping around a little bit in this motion. The motion to suppress is directed only to statements made by the defendant after he was transported from the scene and initially interrogated at the Claremont County Sheriff's Office and then transferred to the county jail. There are essentially 3 instances of custodial statements obtained from the defendant the motion to suppress challenges. And when you hear words like custodial statements, we're going to discuss what that means as we kind of discuss Miranda in this deep dive. The first instance is the custodial interrogation that took place in a small interview room at the sheriff's office on June 15, 2023. No doubt that is a custodial interview. He is there. He cannot leave. They are asking him questions that anyone would expect to elicit incriminating responses. That's kind of what it has to be in order for some of these rights to be triggered. But the second is the butcher interview that took place on June 16th in the defendant's jail cell after he was transferred from the sheriff's office. Ms. Butcher is a mental health social worker employed by a private entity, Child Focus, Inc. Her interview related to the potential mental health issues of the defendant at that time. Is that custodial? We'll talk about that more as we go through this. The third instance, the Griffin exam, occurred on June 17th, 2 days after he was arrested, also in the defendant's cell. This third instance was initiated by the defendant as he was complaining of chest pains and requested medical attention. These statements were elicited solely in response to Nurse Griffin's questions related to his claims of chest pains. Okay? So those are the three instances. And we're going to talk about whether or not you have a right to an attorney if you request emergency medical care in a jail cell. What are your rights and expectations of privacy in a jail cell? All right. So first, the custodial interrogation. He raised 5 challenges. Number 1, that Detective Ross failed to properly advise the defendant of his pre-custodial interrogation rights as enunciated by Miranda. And then number 2, a valid waiver of the defendant's Miranda rights was not obtained because Mr. Doerman was never presented with a written copy of his rights. Third, a valid waiver of the defendant's Miranda rights was not obtained as Mr. Doerman was never asked to sign a written waiver. Number 4, the defendant unequivocally invoked his right to counsel, yet the custodial interrogation continued thereafter unabated. And 5, the detectives employed outrageous police conduct during the custodial interrogation to such an extent that the will of the defendant was overcome, thereby rendering any statements made during the custodial interrogation involuntary. So these are kind of 5 different reasons they feel the defendant's statements should be thrown out during this interview. Again, we're focusing on just the police custodial interview in the interrogation room, which was absolutely a custodial interview. The other 2, maybe not. We'll talk about them later. So the court right away says these 2 about the written waiver and signing the written waiver, they're going to throw those out immediately. They are without merit. The court reaffirmed the following well-settled principle of law regarding these claims. After reading the Miranda warnings, and they're referencing another case, detectives asked whether he understood. He nodded his head and continued to answer questions. TDS pointed out that he was not given a written copy, he did not sign a waiver, but there is no requirement that a waiver be written. Now, there's some arguments in case law that say it should be done that way, but it is absolutely not mandated here in Ohio. Okay? So they basically throw out claims 2 and 3. So we're not really going to discuss the written waiver part. What we are going to discuss is whether he was properly advised, whether he requested or invoked his right to counsel, and then whether the police employed outrageous conduct. We're going to jump down to page 5. All right, so they also discuss, like, because of his mental condition, he was coerced or overpowered. And the court says there is no evidence before the court as to the defendant's mental condition during the custodial interrogation. Again, the defendant did not testify, nor did he present any other evidence to even suggest what his mental condition was at the time. The defense did not cross-examine the interrogating detectives to ascertain their opinions of the defendant's mental condition during the process. Further, the defense does not elaborate or identify what evidence constitutes the totality of the circumstances relative to the above claim. A court is not required to scour the record for evidence to find support for a movement's argument. So they just basically say, not really an issue. We're not going to discuss necessarily his mental condition. But here are the claims raised to discuss the outrageous police conduct. Chad Doerman was in jail, had no power, no agency in the situation. No one in his position would reasonably think otherwise. At least one CCSO officer threatened him prior to this. They said outside the cruiser where Mr. Doerman was sitting, loud enough to be heard. Is that the mother effer? Yeah. Shut the door so I don't effing kill him. That's what a cop says right outside the door of the cruiser where Doerman was being held. CCSO detectives had previously ignored his request for counsel. Detectives used coercive tactics during the interrogation of June 15th, including Detective Ross comparing him to a monster. His mental state was such that he could not make a knowing, intelligent, or voluntary consent to police being present. Had he been asked, he was in no condition to object to their presence. He was not informed of the recordings and did not know the police were recording the conversation. The outrageous police conduct herein should not be countenanced. So the court also just very quickly throws out the fact that it was being recorded as some kind of issue. but we'll talk about some of these other things. Okay. So the court says that the defendant just basically makes conclusions. Again, we have no evidence to support an issue with his mental state, number one. Number two, the statements that put him in the car or leave him in there so I don't effing kill him. The court finds that there was no evidence that the defendant ever even heard these or that they affected him in any way. And number three, the comments about comparing him to a monster were so limited and insignificant throughout the 2 hours that he was questioned that there's really no evidence to say that the police were really outrageous in their conduct. Additionally, during this 2+ hour interview, Mr. Doerman, the defendant, was given water, Coca-Cola, and dipping tobacco. And his hands, he was actually offered food and medication, but he declined. His hands were cuffed in the back and they were loosened and moved to the front so he could drink and dip. And he even said and acknowledged that the officers were being kind to him in this interview. So basically the court says, no outrageous police conduct. But let's discuss. Was he advised of his Miranda rights fully and correctly? And did he invoke his right to counsel that was ignored? That's really what we need to focus on here. So first, on page 9, we're going to read Justice Ginsburg's explanation of Miranda. To summarize, we hold that when an individual is taken into custody or otherwise deprived of his freedom by the authorities in any significant way and is subjected to questioning, the privilege against self-incrimination is jeopardized. So he has to be taken into custody or deprived of his freedom. Procedural safeguards must be employed to protect the privilege, and unless other fully effective means are adopted to notify the person of his right to silence and to assure that the exercise of the right will be scrupulously honored, the following measures are required. So unless you just explain it in a verbose way that you take all the time in the world to check all the boxes, you have to do it this specific way. And you're seeing why most good officers have a card or something that they read off of because their summaries often fall short. I added that. That's not in her summary. He must be warned prior to any questioning, that he has the right to remain silent, that anything he says can be used against him in a court of law. He has the right to the presence of an attorney, and that if he cannot afford an attorney, one will be appointed for him prior to questioning if he so desires. So why the fourth point? Well, if you just tell somebody you can get an attorney if you want before questioning, and they're thinking, I'm poor, I can't afford an attorney anyway, so why even ask for one? That's why you have to say number 4, so they know even if they can't afford an attorney, they can still get one. The opportunity to exercise these rights must be afforded to him throughout the interrogation. After such warnings have been given and such opportunity afforded to him, the individual may knowingly and intelligently waive these rights and agree to answer questions or make a statement, but unless and until such warnings and waiver are demonstrated by the prosecution at trial, no evidence obtained as a result of the interrogation can be used against him. That means we throw this stuff out if you violate the defendant's rights, which is absolutely how it should be, so people don't get railroaded when they don't understand what's going on or cops are trying to pull one over. We don't want that. Then again, they review a ton of cases about how when they use the wrong word or they don't tell them a lawyer can be paid for them if they can't afford them, or if they just skip the first part, or if they don't let them know that the words can be used against them, or if they just say the right to remain silent, but not that the words can be used against them. They go through all these little ways that show you what a stickler it is and how important it is to be exactly precise to get everything across to the defendant that's necessary. And as an example of that, we'll look at the way that the court sets out. Here are the 4 things that must be warned of prior to any questioning right here. 1, that he has the right to remain silent. 2, that anything he says can be used against him in the court of law. That 3, he has the right to the presence of an attorney. And 4, that if he cannot afford an attorney, one will be appointed. All of the case law is clear. So now we jump to this case. The ultimate questions here are whether the Miranda warnings read to Doerman on June 15th comply with the 4 invariable warnings required by Miranda, or if not, a rigid incantation of those warnings were they a fully effective means adopted to fully notify him of his right to silence. So there are magic words. If you don't use the magic words, it's not automatically thrown out if you explain it in another way that still gets the point across. If not a rigid incantation of the Miranda warnings, did they touch all the bases required by Miranda? Or did the words used explicitly advise him of the full contours of each Miranda right, thereby communicating to him the same essential message? State's Exhibit 4A records Detective Ross's re-entering the interview room with Doerman at approximately 38 minutes or 12:38 a.m. I'll just call it 38 minutes so we can see how the progression. He brings with him a small black binder or folder and sets it on the desk. He then adjusts the handcuffs as noted above to loosen them. At 39:44, he tells Doerman he wants to talk to him about what happened today, but I got to read this to you real quick. All right. I read this to everyone, all right? And Detective Ross has in his hand the standard business card size Miranda warnings issued by the Claremont County Sheriff, the rights card, and it reads as follows. Here's how the card reads that the cops are supposed to read off of. Oral warnings to be given to a subject prior to interrogation. Before we ask you any questions, you must understand. And then they just read it verbatim. You have the right to remain silent. Here are the 4 points. Anything you say can be used against you in court. Number 3, you have the right to talk to a lawyer for advice before we ask you any questions and to have a lawyer with you during questioning. Now, it's a little different than some of the case law, but these are the specific issued Miranda warning cards, the rights cards that they should read. And number 3 is the important one. Then number 4, if you cannot afford a lawyer, one will be appointed for you before any questioning if you wish. Do you understand these rights? Are you willing to answer some questions? That's it. Do your job, read it right. But that's not what happened here. So I'm going to leave them both on the screen at the same time so you can see. Here are the 4 points with these dash marks that are written on the literal rights cards. And on the recording, here is what Detective Ross advises Doerman of. Number 1, you have the right to remain silent. We're good so far. Those match. Anything you say can be used against you in court. Anything you say can be used against you in court. But number 3, you have the right to talk to a lawyer before we ask you any questions. You have the right to talk to a lawyer before we ask you, sorry, that's not what it says. So he says, you have the right to talk to a lawyer before we ask you any questions. The card says, you have the right to talk to a lawyer for advice before we ask you any questions. And here's the important part, to have a lawyer with you during questioning. Then, if you cannot afford a lawyer, one will be appointed for you. If you cannot afford a lawyer, one will be appointed for you before any questioning if you wish. Doerman then says, yep. Ross says, you understand? Oh, good. And then the court starts to get into their reasoning. As clearly exposed, they say exposed, in State's Exhibit 4A, Detective Ross inexplicably, and I would agree, this is inexplicable. He completely omitted the third and variable Miranda warning that he has the right to the presence of an attorney with you during questioning. He left that out. Clearly not on purpose. Accidental. I don't think he was trying to trick him. But when something like this happens, we absolutely have to protect the rights of the worst kind of people like Chad Doerman. Because if we don't protect the rights of the worst kind of people, they're not going to be protected for anybody. They're not going to pick and choose when you violate somebody's rights. We protect the constitutional rights of everybody in this country. We have to. Also, of critical importance is the detective's failure to adopt any other fully effective means to notify Doerman of this invariable right to fully advise him of his right to silence. So what does that mean? Well, he could have said, oh, and by the way, you have the right to exercise all of these rights right now during questioning, including that lawyer can come and sit right next to you. Anytime we ask you a question, that lawyer that's sitting right next to you, you can ask him, should I answer this? Should we cut off the interview? You have those rights of his presence or her presence right now and throughout the whole interview. So that's not the exact perfect words. That's not what's written on the Miranda card, but that fully explains and, as they say, touches all the bases to explain fully what the Miranda rights are. But he didn't do that. He simply embarked upon his interrogation of Doerman at 40:05. According to the court, it finds that the detective did touch all the bases required by Miranda, and I think he means did not touch all the bases, and the detective did not advise Doerman of the full contours of each of his Miranda rights. And you're seeing Powell and Duckworth and Daly. These are all different cases that they dove deep in this order. The court finds the decision in Powell compels it to answer all four questions as set forth above in the negative. In Powell, that was a typo, by the way, that he did not touch all the bases, I believe. Although he did not entirely omit any information required them to impart. First, the court found the Tampa police properly advised Powell, this is Powell, different case, that he had the right to talk to a lawyer before answering any questions. And while they did not advise him that he has the right to the presence of an attorney, as Miranda requires, they did use other fully effective means to advise him of this right, saying you have the right to use any of these rights at any time during this interrogation. Accordingly, the court found in combination, the two warnings reasonably conveyed Powell's right, not Doerman, that he could have an attorney present. While Ross did advise him that he had the right to talk to a lawyer for advice before we asked you questions, he did not ask him or advise him equally of the right under Miranda and its progeny, as explained above, to have a lawyer present. So he said you could talk to him before, and then you may think as a just a normal layperson, once I talk to them before, then I have to come do this interview by myself, and that's not how it is. Consequently, the court finds that Detective Ross did not properly advise him of the four invariable warnings as required by Miranda, adopt other fully effective means, or notify him of his right to remain silent fully. Okay? So that's the court's reasoning. Then we're going to get into, did he unequivocally invoke his right to counsel? Did he ask for a lawyer? Did he demand a lawyer, in which they should have stopped the interview altogether and waited for a lawyer to show up, as opposed to just continuing asking him questions? So that all happened in the 39, 40-minute mark, right? Well, as noted above, Detective Ross began questioning at 40:05. 5 minutes later, Doerman states, "I'll wait for a lawyer. I really don't know. Give me a couple of days. I can talk to a lawyer so that way I can get nice, good answers." And Detective Ross says, "I understand." So 5 minutes after you read Miranda, even if it's not appropriate or full Miranda rights, you read those rights and you say this, that's an unequivocal demand for counsel. This interview should have been shut down. This court had no other option but to grant this motion to suppress. I fully stand behind the court's decision here, as horrible as it is, as horrible as it seems, as much as we don't want these confessions to go away or the statements that he made to go away. The court is absolutely correct. Frankly, the state should have agreed to this. This was horrible. Just maybe the mess up with Miranda, maybe not enough, but in combination with this, there's really no doubt to me. But let me know what you guys think if you disagree in the comments. To ascertain the full context of Doerman's request for counsel, the court begins its inquiry when Doerman is being escorted from the immediate crime scene to Deputy Rudd's cruiser. Walking along the roadway, Doerman asks Deputy Rudd to get his wallet out of his pocket. Deputy Rudd immediately says, "Shut up, dude. You have the right to remain silent. Effing use it." Seconds later, Doerman responds, "Yes, sir." As the body-worn camera also have the running military time, it reflects that Doerman was escorted in Rudd's cruiser about 16:30 or about 4:30 p.m. on June 15th. So maybe that wasn't military time. Maybe it was just the recording time, the 039 above. Deputy Rudd transported Doerman from the scene, I think that's supposed to be, to the sheriff's office in Batavia. It reflects that Doerman arrived at the sheriff's office approximately 17:57, so about an hour and 15 minutes later. He was then escorted into the sheriff's office and into the interview room. Detective Ross engages the recording to the interview room at 5:51, so now we're almost an hour and a half after he was initially arrested. He enters the room shortly thereafter. For perhaps 2 minutes, Doerman sits alone in the interview room. He makes no statement of any nature. A deputy then enters the room and remains until Detective Ross re-enters at about 38 minutes on State's Exhibit 4A. It's confusing. 38 minutes or so Doerman was in the interview room. Neither he or the deputy guarding him asked any questions or made any spontaneous statements. So what they're trying to set up here and show is, as the court, once the dude said, you have the right to remain silent, effing use it, Doerman was silent. He wasn't just blathering. He wasn't just saying things. Even though that was not Miranda, he is trying to exercise his right to remain silent, the court said. As noted, Detective Ross starts his questioning. Doerman requests a lawyer 5 minutes later. Detective Ross continued to ask a number of questions, most of which were not about the events, but rather questions about prior contact between the 2 years past, how he's feeling at the time. Doerman would respond to some of the questions, but would remain silent after some. At one point, when Doerman was not responding to his questions, Ross asked him if he was thinking and if he was all right, and Doerman did not respond. 42-minute mark, again, this is before he asked for a lawyer. Ross asked Doerman, why don't we do this? Why don't you tell me what's happening and what happened today? Doerman responds over the next 20 seconds or so. He responds to some additional questions posed to him. Between 43 and 44 minutes, he changes gears and asks him when he last ate, slept, if he was thirsty or hungry. Doerman would answer some of these questions and not respond to others. What happened to your family today at the 44-minute mark? He doesn't respond. 30 seconds later, 15 seconds later, somebody make you upset? Doerman responds, but it is unclear what he says. 44:40, between 44:40 and 45:06, Ross poses about 5 questions. Again, now specifically about the day's events. So that would mean eliciting potential incriminating statements. And over the following seconds, Doerman answers some of the questions, but not others. Finally, 45-minute mark, he asks if Doerman was just saying he lost his way. Without hesitation, almost interrupting the detective, Doerman states, I'll wait for a lawyer. So really, before any of the major incriminating statements or discussions happen, he's kind of remaining silent or trying to, and then requesting a lawyer. From his apprehension at the scene, his placement in the cruiser at the scene, during his transport, Doerman remained totally silent for over 1 hour while in police custody. He asked no questions and did not make any statements during this time period. Then, while in the interview room for 40 minutes before Ross began his interrogation, he asked no questions and made no statements. The court can best describe the interview process as one trying to pull teeth, basically meaning as a guy trying to remain silent. His conduct and demeanor, Doerman would at times sit in total silence and not look at Ross or answer his questions. At other times, he would hesitate for a few seconds before responding to a question. His conduct and demeanor from the time he was secured in the cruiser until he asked for counsel is that of a person either unwilling to talk to officers or exceedingly hesitant to do so. In another case that they cited, the court found that an ordinary person would understand the following question, well, before you use it, can I have a lawyer here? To unambiguously refer to having counsel present for the light test. First clause of Doerman's statements, I'll just wait for a lawyer, is not a question, but a declaration that he wants a lawyer. The court believes that an ordinary person would understand this declaration to unambiguously refers to having counsel present. The second clause, I really don't know, could be considered ambiguous. Doesn't mean he really didn't know if he would hire a lawyer, or didn't know if he had lost his way. The last statement from Detective Ross before the statement was made, taken in isolation, and if Doerman had stopped talking at that point, it is possible that an ordinary person might not understand the first 2 clauses, unambiguously referring to having a lawyer present, and lead to finding that Doerman did not unequivocally invoke his right to remain counsel, but he did not stop there. He said, give me a couple of days, I can talk to a lawyer and get nice, good answers. That convinces the court that an ordinary person would understand these declarations unambiguously refer to having a lawyer present, and coupled with a statement, I'll wait for a lawyer, leads this court to conclude Doerman unequivocally invoked his right to counsel. This conclusion is bolstered by Detective Ross's responses to his declaration, I understand, and do you have a lawyer? Therefore, statements tossed. Then the court goes in over the next 10 pages and explains that the mental health evaluation and the medical exam in no way violated his constitutional rights. Each were just a couple of minutes. Neither were custodial interviews because none of the questions that the mental health counselor or the nurse asked could reasonably be thought to elicit criminal responses in criminal statements or in incriminating statements. You have a lot less of an expectation of privacy in jail. And when you ask for emergency medical care, we're not going to say, no, no, no. Do you want a lawyer? Let us read you these Miranda rights. That's not how it works. And that's not how it can work. You lose the expectation of privacy in jail. You know, if you talk to another inmate, or if you talk to a guard, or if you talk on the phone, or if you talk to a nurse and you say things that are incriminating, they can and will be held against you. So any statements made in those interviews, any confessions, any incriminating statements, those can and will be used against Doerman. So let's read the court's summary of its order, and then we'll get to two of the big questions at the end. Here's the order. The defendant's Miranda rights were violated because Detective Ross failed to properly and fully advise Doerman of them prior to initiating the custodial interrogation, and all statements obtained from Doerman during the custodial interrogation shall be suppressed, and the state shall not adduce any of them in their case in chief. So if he would have said, I did it, this is how I did it, this is why I did it, those can't be used. The defendant's Miranda rights were violated when the custodial interrogation continued after the defendant had unequivocally and unambiguously invoked his right to counsel when he told Detective Ross, I'll wait for a lawyer. I don't know. Give me a couple days. I can talk to a lawyer and get a nice, good answers. Therefore, irrespective of the detective's failure to fully and properly advise Doerman of his Miranda rights, as immediately set forth above, all statements obtained during the custodial interview shall be suppressed, and the state shall not adduce any of these statements in their case in chief. The defendant's Miranda rights were not violated due to the failure of the detectives to have him sign a written waiver. The court threw those out quick. The defendant's Miranda rights were not violated due to failure of the detectives to give him a written copy. Statements obtained by the detective as a result of the custodial interviews, irrespective of the violations of Miranda as set forth, were nevertheless voluntary and were not the product of coercive conduct by any detective or any deputy who had any contact with Doerman at any time after his apprehension, meaning they didn't abuse him, they didn't coerce him, they didn't do anything wrong, calling him a monster or whatever else. And then 6, the Butcher mental health interview and the Griffin exam, the medical exam, were constitutionally permissible, and none of the statements obtained from Doerman shall be suppressed. So, what does that mean for Chad Doerman going forward? First off, just because these statements were suppressed, just because this is a win for the defendant, does not mean that he won't still plead. If he really wants to plead guilty, if he wants to take responsibility, if he wants to not get the death penalty potentially, then maybe he still pleads guilty if the state offers him some kind of plea deal. If not, and the offer was always death, plead guilty, get the death penalty, then this just gives him a better shot at trial. So most defendants don't plead guilty to the death penalty. So maybe they're still going to go forward without these statements. So what does it mean? Does the state even have enough evidence? And the answer is an overwhelming yes. The state will have a ton of evidence. Unfortunately, from his wife, who was there at the scene, and other child who were severely injured, from the body cam footage that picked up where the children were on his property, what was on him. There is still tons of evidence against Chad Doerman in this case, the weapon, things like that. Incredibly sad case, incredibly sad set of circumstances, but I don't think he's going to go free, even with this rather large victory for his defense team to suppress confessions and statements made in a custodial interrogation with law enforcement. But it does highlight some serious mistakes of law enforcement, from just overlooking things, not being thorough enough, not reading every word, not fully explaining things. Now you can say, well, once he asked for a lawyer, they weren't going to get any statements later, so no harm, no foul. Law enforcement might as well try, and maybe they would have won this motion to suppress and we would have got these confessions. It's really not how it should be done. And this is why it's horrible to think you just step on rights and figure it out later. I hate to see that. That's not something that will ever be supported on this channel. We're saying, good job. It's okay to cross some lines as long as we get the bad guy. It's just not how it works. It's not how it can work in our country, because too many innocent people get railroaded with things like this. Not everybody that their rights gets trampled on are Chad Doerman. So it's important for us to remember that as well. So let me know what you thought in the comments, where your feelings are. If you disagree, that's okay. If you feel differently about this, that's okay. But let me know if you want me to continue covering this case. It's an incredibly sad one. But as legal things come up, right? Stuff like this comes up. We're not going to be covering every single thing that happens. But if you want some pop-ins when some legal decisions are made, I thought this was a really interesting discussion on Miranda rights, custodial interviews, violating those rights, invoking your right to counsel, invoking your right to remain silent. Really interesting stuff in the law, and you guys usually seem to enjoy it. So I appreciate you guys joining me. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.